We are delighted to welcome you to the second of two webinars considering new legislation affecting construction contracts. Our first webinar focused on procurement reform, looking at what's new and what's changing. Today's second webinar will focus on the updated Construction, Design and Management Regulations, CDM Regs for short, providing initial information regarding the updated regulations, the key changes to look out for, and most importantly, providing some insight into how the regulations are bedding down and the potential impact on the industry. Both of these webinars will be recorded and will be available on our Vimeo site. Details of how to access these will be given later. Before we begin, there are a few housekeeping matters to start with. To minimize background noise, I have placed you all on mute. If you'd like to ask questions, then please do so using the webinar chat function. In order to keep within the 30 minutes, we will answer as many questions as we can at the end of the presentation rather than as we go along. I'm Nathaniel Buckingham and I work in the Construction and Special Projects team, specialising in construction and engineering dispute resolution based in Edinburgh. I'm joined by Colin Archibald, a partner in the Construction and Special Projects team, also specialising in property and construction dispute resolution based in Edinburgh. Both Colin and I regularly advise on construction contract issues and disputes across a range of projects and clients, and our practice areas mean we have already dealt with a number of issues and practical questions about the application of the new regulations. We will start today with a very brief look at why the regulations have changed and remind ourselves of the consultation process which informed the drafting of the 2015 regulations. We will then predominantly focus on the substance of the new regulations themselves, what's changing and what is brand new, picking out what seems to us to be some of the key issues to bear in mind. We will look at the transitional arrangements which are in place, the new health and HSE guidance, and provide some insight into what we are experiencing in the marketplace. I should add that this talk will focus on the application of the new CDM regs to commercial projects, but we will touch on the position in relation to domestic projects a couple of times, as that is a significant area of change.
Thanks, Nathaniel. I'm going to start by looking at why the regulations have been changed and how the changes have come about. As many of you will know, the first CDM regulations came into force in 1994, looking to implement a European directive as an attempt to improve the historically poor health and safety record of the construction industry and to reduce the number of accidents, injuries and deaths as a result. The 1994 regulations were substantially updated in 2007, and even when the 2007 CDM regulations were going through Parliament, to ensure there was a mechanism for continual improvement, it was agreed that they would also be subject to an early review. The detailed process that followed ran over a number of years, culminating in the 2014 consultation that helped to frame the final form of the 2015 regulations. But before looking at the substance of the new regulations, I think it's worth reiterating some of the key issues that have informed the plan to further revise the 2007 version. The post-CDM 2007 consultation drew the following broad conclusions: that whilst the impact of CDM 2007 was seen as more positive than that of CDM 1994, concerns remained, including, first, a continuing issue with a bureaucratic approach to implementing the regulations; secondly, and perhaps as a corollary to a bureaucratic approach to implementing the regs, a heavy-handed approach to assessing competence of project personnel; and third, issues with the coordination function in the pre-construction phase, which was perceived often to be a box-ticking bolt-on rather than being embedded in and adding value to the project. As a result of these concerns, HSE thought it was important to simplify the regulations, and the underlying aim has apparently been to simplify that structure to reflect the life cycle of a construction project. One aspect of achieving this goal is the impending replacement of the role of the CDM coordinator, or CDMC, with that of the principal designer. There seems to have been a particular concern that the role of the CDMC had become too bureaucratic. The CDMC was often appointed too late and wasn't sufficiently involved in the pre-construction phase. with obvious potential consequences for the effectiveness of their role. I'll look at the role of the principal designer further in a few minutes, and how they should be more closely involved in control of the pre-construction phase, a clear difference from the position of the CDMC. Another driver for simplifying the regulations has been to facilitate more effective use of them on small sites. As we'll see, extending the application of the CDM regulations to domestic clients is a key change being implemented by the 2015 regulations, and one which seems to me to make sense in light of the statistics about where accidents on construction sites are most likely to happen. 2/3 or more of construction-related deaths now happen on small sites where fewer than 15 people work. In circumstances where overall numbers of fatalities and serious injuries in construction sites have fallen, that does perhaps also support the argument that health and safety is being better managed on larger construction sites, and hopefully the new streamlined regulations will assist that process further. At least to some degree, the proposals for simplification had been popular, but some concern was expressed about transitional arrangements, where the application of the new regulations will be wider. We'll come back to look at those transitional arrangements later. So with that taster of some of the key drivers for change in mind, what has changed and what is completely new? Probably the obvious starting point for the discussion of the impact of the 2015 regulations, the headline change, I think it's fair to say, is a replacement of the role of the CDMC with that of the principal designer. A new role intended to be held by one of the design team rather than a standalone party as before. Designer is widely defined under the new regs as any party who in the course of business prepares or modifies a design, including specifications and bills of quantities, or instructs somebody else to do so, in relation to, amongst other things, a structure, or a mechanical or electrical system intended for a structure. So, to my mind, this definition means that the principal designer could be an architect, an M&E engineer, a structural engineer, a quantity surveyor, or even perhaps a project manager. The key definition to bear in mind is that a designer may be appointed as principal designer if they have control over the pre-construction phase. Whilst therefore the principal designer need not be the lead consultant on a project, in practice that would seem to be the most obvious default position. That perhaps explains why we have been receiving queries from architects in particular as the most likely candidates for that lead consultant role to discuss what the 2015 regulations mean for them and their obligations to manage health and safety risks. That said, the feedback we've had from the market is that at least to some degree architects have indicated a reluctance to take on that role of principal designer. So when working out how these responsibilities should be filled, it's perhaps worth taking a moment to really think about who might be best placed to fulfill the duties of the principal designer. The obvious way to make a considered decision about who should take that role is to look at the roles and responsibilities of the principal designer. These are set out in Regulation 11 and include duties to plan, manage and monitor the pre-construction phase, ensuring risks are eliminated or controlled through design work, passing information to the principal contractor, ensuring cooperation and coordination amongst all parties during the pre-construction phase, ensuring designers comply with their duties, assisting the client in preparing the pre-construction information, and preparing the health and safety file during the pre-construction phase. The general duties in relation to health and safety set out in the 2015 regulations are also relevant to the issue of selection of the most appropriate candidate to be principal designer. These are set out in Regulation 8. A designer, including a principal designer, or a contractor, including a principal contractor, appointed to work on a project must have the skills, knowledge and experience, and if they are an organisation, the organisational capability necessary to fulfil the role that they are appointed to undertake in a manner that secures the health and safety of any person affected by the project. Well, what does that all mean? A designer or contractor must not accept an appointment to a project unless they fulfil these conditions. These fundamental requirements should be at the forefront of any designer's mind when considering whether they have the necessary skills, knowledge and experience to accept an appointment to execute the principal designer role. If they are in doubt, they either need to decline the appointment in favour of a more suitable member of the design team, or take the steps necessary to ensure that they can adequately fulfil that role. It's also worth emphasising that a client cannot abdicate responsibility in respect of these matters either. The client, as the person responsible for appointing a designer or contractor to carry out work on a project, must take reasonable steps to satisfy themselves that the designer or contractor fulfills the requirements of Regulation 8 and is capable of fulfilling the role assigned to them.
So in contrast to the position with the principal designer replacing the CDM coordinator, the principal contractor's title is not changing, but there are some changes to their role. The duties of the principal contractor are now primarily set out at Regulations 12 to 14 of the 2015 regulations. The principal contractor has to plan, manage and monitor the construction phase of a project, coordinating matters to ensure, so far as reasonably practicable, that construction work is carried out without risk to health and safety. The principle of prevention is highlighted as a key factor for the principal contractor to take into account when fulfilling a range of obligations, which include ensuring cooperation amongst contractors, implementation of legal requirements for health and safety and consultation, and engagement with workers. The principal contractor must liaise with the principal designer for the duration of their appointment and share information with them relevant to the planning, management and monitoring of the pre-construction phase. A fundamental aspect of that requirement is the principal contractor's obligation during the pre-construction phase and before setting up a construction site to draw up a construction phase plan or make arrangements for a construction phase plan to be drawn up.
Thanks, Nathaniel. Looking now at the client's role, the 2015 regulations also make clear that the client has an ongoing responsibility to make arrangements for managing a project, including its health and safety aspects. Ensuring preparation of a construction phase health plan and a health and safety file are two examples of what this responsibility entails, as is the fact that in the event a client fails to appoint a principal designer and/or a principal contractor, then they need to fulfil those responsibilities themselves. Even if those steps have been taken, however, clients must not lose sight of their ongoing obligations to take reasonable steps to ensure that principal designers and principal contractors comply with their obligations. It's also the client who actually appoints principal designers and contractors, though I think it is unlikely that professionals would take on roles without informing their clients of their responsibilities under the CDM regs. Where there's more than one contractor, or if it's reasonably foreseeable that more than one contractor will be working on a project in any time, the client must appoint in writing first a designer with control over the pre-construction phase as principal designer, and secondly a contractor as principal contractor. These appointments must be made as soon as practicable and in any event before the construction phase begins. From a client's point of view, it's important that these obligations are made in writing, since if they're not, a client that fails to appoint a principal designer must fulfil their duties as set out in Regulations 11 and 12. And if they fail to appoint a principal contractor, they must fulfil their duties set out in Regulations 12 to 14. A clear appointment which passes on these responsibilities to the principal designer and principal contractor respectively is clearly vital to protect the client's interests. Looking next at domestic clients and also a little bit about project notification. The first of these issues, the application of the 2015 regulations to domestic projects, can be seen as a deliberate attempt to ensure that the principles which inform the terms of the CDM regulations also apply to smaller domestic projects, to try to ensure that the improvements in health and safety in larger projects extend to such smaller scale projects too. In contrast to the position under the 1994 and 2007 CDM regulations, one of the other key changes is that the 2015 regulations now apply to domestic clients, that is, clients for whom a project is being carried out which is not in the course or furtherance of a business of that client. Whilst on the face of it, this is a further significant change, the good news for such domestic clients is that, to a significant degree, Regulation 7 of the 2015 regulations passes domestic clients' obligations on to other parties. The obligations of a client in terms of Regulation 4 and in relation to Regulation 6 regarding notification must be carried out by the contractor for a project where there's only one contractor, or the principal contractor for a project where there is more than one contractor, or finally the principal designer, where there is a written agreement that the principal designer will fulfil those duties. If a domestic client fails to make the appointments required by Regulation 5, i.e. those of a principal designer and a principal contractor, then the designer in control of the pre-construction phase of the project will be the principal designer, and the contractor in control of the construction phase of the project will be the principal contractor. So whilst the 2015 regulations bring domestic projects into the ambit of CDM, the responsibilities fall predominantly onto the professionals rather than the clients. Next, in relation to notification, projects will now be notifiable if they are scheduled to exceed 30 working days with more than 20 workers working simultaneously, or if the project exceeds 500 person days. Where notification is required, the client, except if it is a domestic client, where the responsibility rests with the contractor, has the obligation to notify HSE as soon as practicable before construction starts. This is likely to reduce the number of notifiable projects, emphasising the move away from a bureaucratic approach, with clients, designers and contractors taking more ownership of and responsibility for the health and safety of the projects they are involved in.
We mentioned at the start the detailed transitional arrangements that have been put in place for projects which began before the 6th of April. It's worth emphasising that a project will have begun for the purposes of these transitional provisions, even if the construction phase has not started. If a project involves more than one contractor and the client has not appointed a CDM coordinator, then a client must appoint a principal designer as soon as practicable if the construction phase has not started. On the other hand, if the construction phase has started, the client may appoint a principal designer but doesn't have to, and it will be the principal contractor who must prepare the health and safety file. Where there is more than one contractor involved and a CDM coordinator has already been appointed, a principal designer must be appointed by the 6th of October 2015 unless the project is going to come to an end before that date. The CDM coordinator appointment will continue though through the transition period and has effect until the principal designer is appointed on the project or until the point when the project comes to an end. And in that case, the duties of a CDM coordinator during the transitional period are set out in some detail in the regulations. These include liaising with the principal contractor about the health and safety file, preparation of the construction phase plan, and design development which may affect planning and management of the construction work. However, the transitional arrangements specifically don't apply to various provisions of the 2015 regulation, including Regulation 5.1a and the obligation to appoint a designer with control over the pre-construction phase. This is a key aspect of the role of a principal designer, so this exclusion really highlights the changes being made to the old CDMC role, and certainly our view that CDMCs under the 2007 regulations may not have the expertise needed to fulfill the role of principal designer. There are a number of other important transitional arrangements too. So projects notified under the 2007 regulations are recognised as being notified under the new regulations. So there's no requirement to re-notify for ongoing projects. Similarly, a principal contractor appointed under the 2007 regulations is considered to be the principal contractor under the new regulations, although of course their duties under the regulations will have changed and contractual provisions may need to be updated to reflect that. And finally, any pre-construction information, such as construction phase plans or health and safety files that have already been produced under the 2007 regulations are recognised as meeting the equivalent requirements under the new regulations. That's a pragmatic approach to the transition, but which may not be obvious, especially where the requirements have changed significantly under the new regulations.
Thanks, Nathaniel. I'm now going to look at replacement of the old ACOP with the new HSE guidance. The 2007 approved Code of Practice, or ACOP for short, has been replaced with what has been described as targeted guidance, with a view to trying to ensure that those who might benefit most from understanding the responsibilities of CDM duty holders, perhaps primarily those in smaller businesses, find the regulations easier to navigate. Feedback on the ACOP suggested some users found it inaccessible due to its length and complexity. At the other end of the scale, those with more resources who were perhaps better positioned to interpret the regulations in some instances actually over-interpreted them. So whilst the approved Code of Practice produced for CDM 2007 is being withdrawn, HSE has produced detailed guidelines on the operation of the 2015 regs, and these new guidelines are in two parts. The first is an HSE publication setting out the legal duties under the CDM regs, sitting beside the text of the regulations themselves. This mostly provides a non-legal statement of the legal duties found in the regulations, so that these can be readily read and understood by any party to a construction contract. The second set of guidance has been drafted by professionals under the auspices of the Construction Industry Training Board. Each party within a project has a separate guidance document available, meaning that you only have to read and understand the guidance document applicable to your participation in the project. On the face of it, some of these guidelines do look helpful, though I appreciate that if you're involved in projects at the coalface, you may have a different perspective. One advantage of them being industry guidelines is that they can be modified and updated as practice evolves and to suit the new regulations. If you're involved in construction projects, I'd certainly suggest that you read the guidelines relevant to your area of practice. As a further reminder, the ACOP had a unique legal position in that compliance with the suggested practices set out in it was deemed to be compliance with the 2007 regulations, although parties were also free to comply in any other manner as well. The new guidelines don't follow the same approach, and compliance with the industry guidance is not a guarantee of compliance with the regulations, as it would have been under the ACOP. This shouldn't cause anyone undue concern, I wouldn't have thought, but should be borne in mind, and again is perhaps best seen as a move away from the process-driven approach to implementation of the 2007 regulations. And what about the bedding down of the 2015 regs and their potential impact further down the line? I think it'd be fair to say that even though the 2015 regulations were well trailed and, as I said earlier, have come about after extensive consultation, there is a sense that the construction industry is having a bit of a battle to get to grips with them. Certainly our impression over the last 6 months is that clients, consultants and contractors had not always seemed overly concerned about the impending changes, and perhaps that's in part explained by the delays in publishing guidance, so that time and effort could be expended reviewing proposed changes only for them to be easily summarised and explained in the guidance. We're now in the transition period, and many of our clients and contacts in the industry are now working hard to consider how best to implement the new regulations before this grace period expires. One of the key questions we've seen crop up is, and I think it's a very pertinent one bearing in mind what we were saying earlier on, whether a CDMC can now just be appointed as the principal designer. Earlier I touched briefly on the point that the answer may be garnered from a look at Regulation 5, which provides that any individual or organisation appointed to or taking over the role of principal designer must be a designer with control over the pre-construction phase. If a party fulfilling the role of the CDMC in the past is a designer exercising such control, then that's fine. If, however, they've been performing more of an administrative and managerial function, then it seems to me that a client may need to look elsewhere during the transitional period for the appointee to take on the role of principal designer. This perhaps also highlights one of the points I flagged earlier about the drivers behind the changes that the 2015 regulations are bringing in. The HSE are keen to see any tendency towards a bureaucratic approach to implementation of the regulations disappear, And at least in theory, it seems to be that replacing the CDMC with a party exercising an element of design control is a sensible way of trying to achieve that end result. We've certainly seen and heard of CDM coordinators offering to assist designers with their role as principal designer, effectively acting as a bolt-on to the designer's offering. But designers should be a little wary here and be clear that they can satisfy the regulation requirements for competency, which may not be achieved through simply outsourcing the role. One of the other key impacts is certainly the responsibility of the client, which has an increased focus. All of us who advise clients should be ensuring that they are up to date with the regulations and understand their duties under them. We've had generally positive feedback from the marketplace, at least about the principles behind the new regulations, returning the management of health and safety to those best placed to deal with it. Lead designers during the design phase and contractors during the construction phase. And certainly a move away from a box-ticking culture seems to appeal to those who are most interested in improving the construction industry's record on health and safety.
Thanks, Colin. We've now come to the end of the presentation, which we hope has been useful and interesting. And we obviously still have a few minutes to answer any questions. So if you haven't already done so, please type your questions into the chat box now. While you're doing that, I'll just take the opportunity to remind you that both of these webinars in the series will be recorded and will be available on our Vimeo site. So please do share the link with colleagues who may find this webinar useful, details of which are on the screen, and we will also be circulating details of the recording to participants after the webinar. We'd also ask you to feedback on the format and content of these webinars so that we can continue to improve them, and are particularly happy to hear participants' thoughts on future topics that you'd like to see covered at one of our next webinars.
Thanks, Nathaniel. There were actually a couple of questions that we had come through in advance, so I was just going to deal with them first of all. One of those questions was about the application of the CDM regulations to, for example, general repair and maintenance works, PPM regimes, that sort of thing, perhaps in the context of a local authority with properties to maintain, or a housing association with a significant portfolio of properties to deal with as well. I think that the long and the short of it is that certainly from some of the advice we've given on this issue to date, that whilst ultimately the classic lawyer's answer is it will depend on the precise nature of the works being carried out. But if you look at the definitions under the regulations, in many cases the CDM regs will apply to repair and maintenance activities. We've obviously only got a limited amount of time, so this is a very quick scoot through some of the key definitions to look out for. But if you look at clause 4.1 of the regulations, it provides that a client has to make suitable arrangements for managing a project. If you then look at the definition of project, and I'll not read out in view of the time being short, that has a pretty wide definition, which in turn refers to construction work. And again, the construction work definition is a pretty broad one. Just to give you a flavour of how broad that is, it talks about the carrying out of any building, civil engineering or engineering construction work, and includes construction, alteration, conversion, fitting out, commissioning, renovation, repair, upkeep, redecoration, or other maintenance of a structure. So if you have a look at the regs and those two definitions, clearly it may be that scrubbing the floors of a housing association property, or carrying out some cleaning works may not come within the definition. But there's even some provisions in relation to the use of perhaps best described as noxious substances, which might bring the regulations into play. So I think that's a long answer to a short question, is in many instances the regulations will apply to that sort of planned preventative maintenance type regime. There was also a question that came through on the chat box earlier on about whether the regs apply to projects that are non-notifiable, and the short answer to that is yes, they will. Again, you'll have to look at the definition of a project, the definition of construction work and so forth. But if you piece those bits of the jigsaw together, I think it's fair to say that there is going to be a pretty narrow scope of projects that are not governed by the scope of the regulations. The second question that was flagged in advance, and again I think there have been some follow-ups come through in the chat box in the last half hour, is just the thorny issue of whether which parties can fulfil the role of principal designer. The specific question we were asked in advance is, could it be a health and safety consultant? And once again, it comes back to this whole issue of whether the potential candidate for appointment as the principal designer has control, any element of control over the pre-construction phase. Now, I know from some anecdotal evidence that former CDMCs have been looking to rebrand themselves for perfectly understandable reasons as principal designers, and doing that on the basis that, say, they're carrying out some overarching review of the design process. I think in each case you'll need to interrogate whether whatever role is being carried out truly involves that element of control over the pre-construction phase. That's why, as we said earlier on, obvious people to fulfill that role might be your architect as lead consultant or your structural engineer. If to any degree the health and safety consultant is exercising that element of control, then the answer may be yes, but I think that would need to be interrogated pretty closely to work out whether they do meet the requirements of the regulations. I think, unfortunately, time has now run out. We've had quite a number of questions come through, and I'm afraid in the half-hour slot available to us, we're not going to be able to cover all of them off, but hopefully the two that we have managed to address have been of some assistance, but clearly there is always the possibility of subsequent follow-up, and no doubt there will be much more to this discussion to come, both as the transitional arrangements expire in October and beyond, about the bedding in of an application of the new regulations.